AA, and you are now rocking with Mickey Truth. She live up to her name, not the fame. So make sure y'all subscribe to her channel and stay updated on what's real. Bye.
Good reporting ass Mickey.
We love you, Mickey.
Mickey talks the truth. Make sure you like, comment, share, subscribe. Tell a friend to pull up on your girl, Mickey Truth. We is live with it. Good morning, everybody. I'm late. I almost didn't come on this morning. Then I'm like, you know what? I already got myself in a tight situation by taking 5 days off. So I said, let me get my ass on here. Good morning, Blue. We're gonna tap into the YSL trial. I'm gonna see what they talking about because it's not a jury day, and legal arguments is not always interesting, but we'll see. So I'm gonna go ahead and start it now, and then we'll go from
there. And wanting to share with the community and making sure that it is a fair trial.
Okay, so I don't know if you mean angle as in position that you would take in your reporting or angle as in camera angle.
When I say angles, meaning that, for example, there's a camera on right now,
right?
That I'm looking at. So if I want to report something or show something and it's not from his angle, that means if I have to jump on what he's doing, I'm relying on his footage only.
So you actually literally mean camera angle?
Yes.
Okay,
yes,
which
camera
is
angle.
Either going to be on the witness, the judge, the state, or one of the defendants.
Yes, but it's still the reliance of me depending on the footage. And I'm pretty sure the footage that they have, I know any other time I've worked with 2.5 and 1146, there's an approval process for that footage. And I will also be dependent on that sometimes as well. But if I'm able to stream myself, then I have more control of that footage.
Okay, well, if you want to go back in the media room and film from there, you may do that.
Okay.
Okay. All right. All right. Anything else?
No, Your Honor.
Okay, thank you.
Yeah,
all right, and
Miss Paul, letting this shit go.
Good morning. How are you?
Good morning. I'm fine. Thank you for your time today.
Sure. And you want to do still photography and audio?
Yes, ma'am. My situation is a little bit different, even though I do have a YouTube channel and I can pull from the pool, which I have done.
Okay.
Because I'm a freelance blogger, I can't depend on the pool for still images. So my situation wouldn't be setting up tripods or anything of that nature. And I would ensure the integrity that I'm supporting, especially from our seating that we have, that we don't compromise any integrity of jury or anything of that nature.
All right, and you'd be able to, you say still photography and audio, you'd be able to pull audio from one of the pool sources already.
Yeah, I can pull audio from pool.
Okay. And what kind of equipment are you talking about?
Sony AX50, one of those type of still cameras.
Does it make any noise?
I will make sure the settings are off.
All right, you're going to need to be wherever it is that the deputies put you.
Yes, ma'am.
And you're not going to be able to move around.
Yes, ma'am.
Okay. All right, and what's the camera?
I have a Sony AX1, Canon C50. So I'll work with the settings and make sure which one will be dependable on the fact that it will make no noise.
All right, and you'll be the one operating.
Yes, ma'am.
Okay. Thank you.
Thank you.
All right, Ms. Abbasi, did you just get alerted this morning that you were going to be the one covering court?
Is it granted?
Yes.
Okay,
We'll get the paperwork out to y'all probably sometime today.
Okay, thank you so much.
Okay.
My apologies for and everyone else.
Well, since you didn't know until, I guess, a few minutes ago, nothing you can really do about it other than get here as soon as you could. So I appreciate you doing that. All right. Does anybody have an issue with anything that occurred over the course of the evening that y'all need to bring up with me? Or is everybody fine? Yes, sir. Well, Mr. Sharp stood up first.
Your Honor, we came in today.
Why did they go to that? What the fuck happened just that quick? What the fuck? Is it something that's supposed to be private? Okay. Look, I don't know why the hell it went to that. Shark stood up and why is this loose like this? Oh shit. I don't know. I don't know, y'all. That shit just went. Yeah, I hope my sound stays clear to. I can never understand which way I should be like. Okay, I guess I gotta go this way. Okay, so I can be in front. They moved the defendant seating. It seemed like they came. I think those probably are the ones that got an argument. I'm not sure, but them going to that picture, I'm confused why the hell they did that. But nevertheless, here we are. It seems like it might be some interesting shit this morning. So we're gonna ride it out for a little while. Like I said, it's no jury in today. They're just doing, I don't know what the fuck they're doing. We heard like some Route 22s arguments or whatever. I hate to call it an argument, but I guess motions. And then this happened. I don't even know why it happened, but this happened. And then so we're gonna see what happens, and then from there we'll kind of go with the flow on what we're gonna cover. Hopefully the audio stays good today. And then hold on, I don't like how this looks. Hold up. Then we'll go on to something else if time permits. I'm not planning on being on live all day, but I am planning on being for like 4 hours. So if this dries up, we'll do something else. We'll find something else. Other than that, I'm really like, what the fuck? At this moment. Like, I really don't know what happened. Ryman, good morning. Good morning, everybody. Did I say good morning, everybody? If I didn't, I'm saying now. Good morning, Blue, Nikki, Jeff, Grammy. It was somebody else I saw. Who else was it? White Now TV. Yeah. Good morning, everybody. Y'all make sure y'all hit the like. Y'all know currently I'm shadow banned. So hitting a like and sharing the lives or the videos is going to help me get unshadow banned. So that I can get back into the algorithm so that my numbers can look better. Because right now they look sick. Okay. But I'm still here. Look, I'm still here. I almost didn't get on this morning. I have recorded a video this morning. But I was like, let me get on live because I don't have time. I worked very hard last month. You know what I'm saying? And yeah. And then it was so crazy, y'all. When I got off live last night, just a little segue. When I got off live last night, remember I was giving I gave the example how people don't never look at the good shit. They look at your worst moment and then they go off of that. So after doing 1.4 million last month, now mind you, yesterday was only the 10th of September. I had somebody in my comments talking about, oh, you might as well just shut down the channel. Your video ain't even get 100 views. Like, bruh, why the fuck would I shut down my channel and I just right there 1.4 million views last month? Like, people just crazy. But that, like I said, that was the example I was giving y'all last night when we were talking about the whole Lil Wayne Hurricane Chris situation. But yeah. So I mean, I don't even know how long they're gonna be on the screen. I don't know none of that shit right now. Like they really just segue over there real quick. Let's see. Yeah, everybody's on that. So I don't know. We just here right now. I still haven't heard anything or any more information in regards to Rich Homie Quan's funeral service. So, hopefully if y'all find out information before me, y'all hit me up, send me a message or something, let me know. Cause I've been looking, cause like I said, I do want to be there, but I'm not 100% sure. I gotta make a thumbnail. Hold on, y'all. My bad. I was trying to do too much this morning. I gotta make a thumbnail real quick. Yeah, skip this. I don't know. Skip. All right. If I could get over doing thumbnails, my YouTube experience would be great. All right. I really didn't want to move past it until we knew what's what. Cause that'd be the most aggravating thing. Like jump into another like content and then boom, they're back. All right, we just gonna chill for a second. I need to make this thumbnail anyway. So just give me a second to make a thumbnail for this video I had just made. And then hopefully by there something shook. And if it didn't shake, we'll move on to something else. Delete. I think I already have. I know I got an NBA YoungBoy picture already, don't I? Now I'm really interested in knowing what the fuck happened last night. Cause that was strange for them just to shut that shit down like that. Normally they be done said something. Mm-mm. See, I should have left this shit alone. Now, okay. So now it's under that. I'm coming out. There we go. All right, got my thumbnail done. All right, I ain't back yet. All right, let's get into something else. Let's take a look. Well, I already did a video today, so not that. Did everybody watch the end of the trial yesterday when they was had the Infinity guy on there? I kind of want to see what y'all felt about that. Do y'all think he was accurate in pinpointing that it was an Infinity that was used in the Donovan Thomas murder? Personally, I just feel like I don't think it was a way for him to accurately say without a doubt the car in the picture was indeed the car in the video. That's just how I feel about it. All right, give me a minute, y'all. We about to watch this video about music 101. I want to see what his opinion is. I did a video
to provide me with
we bet.
anything you found between yourself and any of the attorneys for co-defendants who have entered pleas?
Judge, the court gave me until noon.
Oh, okay, that's fine.
Your Honor, I would like, with permission of the court, to check with Ms. Winfrey's exhibits to see that 460 is up there, because I took one stack, but
Okay.
460 was not.
You can check.
Thank you.
And were the parties able to come to any agreement or partial agreement with regard to any of the exhibits that were tendered at the end of the day yesterday?
No, Your Honor,
Y'all haven't what?
we haven't discussed that, redactions. I have gone over the exhibits themselves, and I have a legal argument that I'd like to present to the court regarding 104.
Well, I'll hear it after lunch then, because I instructed you to get with the defense so that you could see whether y'all could come to any certain agreement. So if they haven't seen it yet, then I will give y'all the lunch break to accomplish what you were supposed to accomplish yesterday evening.
And may I inquire what the court inquired, whether 460, which was a document that I believe at the end of the day, some counsel for defense were looking at, I believe that I retrieved it, but I think Mr. Sharp may have had it.
I don't know. Does anybody have 460Y? Can y'all check? Sometimes it's hard to keep track of all the documents.
Now, there were several documents that, someone, I think it was either myself or Mr. Adams, put into the documents, that folder for the documents.
Identified only.
Yes, identified only, I don't know.
Yes. All right. Do you locate it? Were you able to locate it, Ms. Love? Okay. Well, I'd imagine that would be easy enough to reproduce. It was just printouts from emails, right?
It was Wright's emails.
I mean, yeah, I'm sure I have a copy of it since you gave it to me, if that would help.
It would, if the court doesn't mind allowing us to have a court's copy, I will,
Okay.
return it back.
I don't think I've made any markings. Well, I have made a marking on it, sorry.
It would actually help us to recreate it.
To just, yeah, look at it to recreate it, that's fine.
Thank you. Thank you very much.
Nobody was able to find a 460Y anywhere? Okay. Has anybody checked up in that podium area? Okay. All right, well, it can be reproduced. It's not the end of the world if we can't find that particular one. All right, turning to the issues we need to decide. Ms. Abbasi, your co-counsel had filed a motion in limine regarding autopsy photos from the Holmes murder. Is the state ready to respond to that?
Yes, sir.
All right. And Ms. Abbasi, do you want to make any argument?
At this point, no, Judge, the motion is largely self-explanatory.
All right.
Thank you, Your Honor. Good morning.
Good morning.
Your Honor, when we get to presenting this act, which is count 1, Act 79, the state intentionally did not include the medical examiner. This is a case in which Mr. Ryan has been convicted of the murder of Jamari Holmes. And so it is only the state's intention to bring in 3 photos, and I have a copy of those 3 photos that I can show Ms. Abbasi through the lead detective in order to minimize that level of testimony. And so we do not plan to stipulate, but we've selected only 3 photos that we intend to.
All right, let's see what they are.
And I can bring them up to the court for the purpose of this hearing. Yes. And for the purpose of this hearing, Your Honor, the state's going to label them states 1 RR, states 2 RR, and states 3 RR.
And what do y'all plan to present with regard to, just kind of a general overview, the evidence that will establish that Act 79?
Generally, Your Honor, what occurred leading up to the homicide of Mr. Holmes, which was a luring of Mr. Holmes to an apartment complex that Mr. Ryan and Mr. Blaylock then, we believe, ambushed Mr. Holmes along with 2 other victims. They were in a vehicle. Mr. Holmes was shot, and then they fled. And then subsequent to that, there were Instagram postings, Facebook postings, social media postings regarding YSL, very close in time to the murder of Mr. Holmes, Your Honor.
All right, and how many witnesses are you going to utilize?
For that act, we have 5 witnesses.
Who are they? And what will they generally testify to?
You know, that 5 is a marked reduction from the original list of witnesses. We did not intend to retry that murder.
Well, that's good to hear.
Your Honor, 5, the witnesses for that act are Ms. Sharon Latner's, Starry Holmes, who's the mother of Mr. Holmes. Mariah.
An eyewitness?
No, she is just would be able to bring in his in-life photo.
Let's
And
figure
it's
out a
talking
different
about
way
Mr.
to do
Holmes.
that, especially given that this is not even the trial of that case.
And speak about Mr. Holmes and who he was. Okay.
I have a relevance objection on that.
And that would be sustained.
And to talk about his involvement, who he is as a, prior to this murder happening, he was a juvenile. I don't know if any of these other witnesses would be able to do that. Mariah Smith was someone, I believe he had just met recently, who helped set up the robbery that ultimately led to his death.
Okay, all right, have you moved on to another witness now? Is Mariah Smith another witness or?
Mariah Smith is another witness, Your Honor.
So Mariah Smith would be able to say he was a juvenile, right?
She doesn't, I don't believe she really knew Mr. Holmes.
How old was he?
substantially. He was 15 at the time of his death.
Mhm.
Next.
And Ms. Latner's backing up, she would, what, introduce a 911 call?
Yes,
And what's that gonna say?
But it was the initial reporting of the shooting. So it was set the time, the time of the shooting.
Just
framing
one
the date.
call?
Yeah, I believe just one call, Your Honor.
Judge, we would have no objection to the call.
Okay.
Admitted where, the witness says he'd like to speak with police and police don't speak. No problem with that call coming in.
Is that the call?
I don't think that that's the call. I think that the initial call about the shooting.
That may be a different call.
Yeah.
It's a different call.
Okay.
And
Okay, so,
the witnesses are our skeleton version of what we can present to show absent, because we cannot just put in the certified to show the facts of the case. So we're trying to put in.
well, I mean, sure, the fact of the murder wouldn't get it as an overt act that is a part of Rico. So I understand you need to do a little bit more than that.
Right. And so we're trying to, we've scaled back. We had these
Okay.
witnesses.
I don't
represent
need to
one of-
hear what it was gonna be at one point in time. Maria Smith is going to say what?
She was one of the two young ladies who lured Mr. Holmes and his three friends back
Okay.
to the location, or to the location.
All right,
Then we have one of the two other victims. We don't plan on calling both of them.
okay,
So that it'd be either Mr. Uten or Mr. Mitchell.
all right,
Then we have the lead detective on the case, who is Detective Hogan. Then we have Mr. Mike Sprinkle, he further brought the
He'll-
additional evidence of some of the social
Social
media that came in later. And then last, sort of,
so 7, not 5.
so Rooney Lee is one of the co-defendants or co-conspirators in this case. He is coming in during this portion, but he was present during the initial trial of Mr. Ryan and posted some social media postings with rat emojis when Miss Mariah Smith initially testified in that trial. And so he's coming in that portion, but he's not actually a part of what will prove the actual act, but that's why he's included.
And Your Honor, we do need some clarification whether it's going to be Mr. Uten or Mr. Mitchell. We've been in contact with the state about going through the evidence we've offered for these witnesses, what does or does not need to be redacted. Mr. Uten's interview is.
Can y'all spell that last name?
Yes, Your Honor, it's OOTEN.
Okay.
His interview is maybe about 20 minutes, half hour with some quiet time, and Mr. Mitchell's interview is several hours long.
Okay. When are we gonna get to this part of the trial?
Your Honor, we would believe that we would get to this portion of the trial probably early October,
Okay, so fairly soon.
fairly soon. Yes,
All
Your
right,
Honor.
when will y'all know who it's gonna be?
We should know within the next few weeks, within 2 weeks, Your Honor.
Your Honor,
Well, 2 weeks from now is the end of October, so. I mean, the end of September, trying to rush that along.
Your Honor, we do want to have an opportunity to go through the state what evidence they believe will actually be admissible. Right
Okay.
now, we've got more than 50 pages of Instagram records from Mr.
Laylock, co-defendant, not testifying, more than 200 pages from Mr. Ryan. Those are obviously issues we'd rather not sit down with the court and go page by page, but if we need to, then we will.
And I believe there was some preliminary conversations, and we do intend on furthering or finishing those conversations with Ms. Abbasi and Ms. D. Williams.
Okay, well, that probably needs to get done before the end of next week.
The state could respond to our email.
Can y'all,
We can. We've also found it fruitful to communicate via phone, which we have done and will continue to do at times that are convenient for either Mr. Bossie or Mr. Williams. That communication has not stopped. I think there were some issues, but we've done that as well.
all right, well, try to do it in a timely manner, please. Okay, let me see the photos. And the photos would come in through the detective. Did you get copies too, or are we just? Is this third one like post incision, or is that the exit wound?
That is the entrance wound.
Entrance wound?
Yes, Your Honor.
Your Honor, one of our objections is I don't know who's going to be able to answer that question. I don't believe the lead detective is qualified to explain what type of injury you're doing. We don't believe the detective will be able to lay the foundation. Oh, I'm sorry. We don't believe the detective will be able to lay the foundation for these photos.
All right.
We believe that with some conversation, he can talk about the fact that the victim was shot in his head, that is the victim, that he was it was his homicide that he was investigating. The picture, which I believe is 2RR, with just the area in which the
Before it's shaved.
before a shave, I believe that he could talk about where the bullet was, or that he was shot in the head. And then the last photo, I'm not sure if he'll be able to say it was an entrance wound. We'd have some further conversations with him regarding whether or not he was present during the autopsy or not, and whether or not he
Do you think that there's any chance he was present during the autopsy?
sometimes they are. Sometimes they are. I'm not saying that he would, but sometimes they are present during the autopsy.
Was he present at the scene before the body was removed?
Yes, sir, I believe so. I believe so, but I need to ask. Ms.
Okay, well, y'all.
Ms. Love. Do you know if he was present?
Your Honor, I've got, based on the police report, the officer received his phone call at 6:07 requesting assistance to the homicide. The victim had already been taken to Grady in ambulance 571. He was pronounced dead at Grady at 6:10.
Okay, so if he was at the scene, he wouldn't have seen the victim at the scene,
correct.
so that wouldn't be helpful with regard to these photos.
And Your Honor, we were trying to avoid the ME, so if we can have some stipulations to that, or we can have the ME come in for
All right,
amendments and purposes.
why don't y'all get together? I'm gonna hand these back for now and come up, maybe you could come up with all sorts of stipulations. So we'll revisit that.
But we are just trying to reduce the need of having to call the medical examiner.
Say that again.
We are just trying to reduce the need of having to call Dr. Sullivan.
Well, there's no necessity to call him or her. Can't remember. Thought so. Okay.
list. I cannot remember if the state is moving for the verdict against Mr. Ryan into evidence, but I would be objecting under 24-8-80322. And I'm just reading from a case, a jury's verdict that the co-defendants were guilty as a hearsay statement. The exception to the hearsay rule provides for the admissibility of the final judgment of guilty as to a felony, but not including when offered by the government for purposes other than impeachment judgment against other persons other than the accused. And then I just pulled up 24-8-803, and then it's subsection 2.2, and it specifically says the same.
What's with the state's plan with regard to that?
I just want to put you on notice so we don't go into it.
As to the conviction itself, Your Honor, I believe that it would not be improper, and I'll reread the case law on that. I don't believe that it would be improper to limit, as the court did earlier with the conviction itself of the witness. Actually, because it was not a statement that he made, actually, Your Honor, I think that it would be admissible against all of them. It wasn't a guilty plea, so it's not a statement that the
It's any judgment of previous conviction is what 22 covers.
okay.
So
So to the extent that the actual certified is tendered, then if it is the fact, and it could, we don't argue that it, it's probably the fact that that certified alone is admissible only against Mr. Ryan. But the facts of the murder itself and the circumstances and what he did, we'd argue are admissible against all of the defendants in this case. So,
the facts,
yes.
right.
Not the actual certified, but I was speaking Ms. Hilton, not the court.
I can't hear you. I mean, I know that mic doesn't want to behave properly, but maybe you can borrow the witness stand mic if that one was even working yesterday.
It wasn't. I'll try to hold it carefully. So the certified itself, we may have no argument regarding that being used and there being a limiting instruction as to the certified itself against Mr. Ryan only. But we would also ask and would craft and present to the court an alternative if there is an instruction that is requested that includes language that the facts that are presented that the jury takes as evidence are admissible against all of the defendants, including any postings or statements that Mr. Ryan or Mr. Blaylock made as a result of or in furtherance of that act.
Okay.
It seems, Your Honor, as well that while the court can't hear us, it seems that while the court can't pick us up, somehow or another, the person who is running the camera, he hears all of our.
That is irrelevant to me.
I know.
I mean, I'm not worried about how the media can or cannot hear I'm worried about whether the parties in this case and the court and the jury, when the jury's here, is able to hear.
Yes.
So they'll just have to deal with it.
Because the issue was, they can hear our internal.
Oh, they can hear what y'all are saying there at the, so that's getting picked up?
Yes.
Well, that's problematic.
With all the mics off.
Okay, so y'all are gonna need to adjust your microphone in a way that is not picking up attorney work product conversations. Can you do that?
You just get the fees from the courthouse.
Okay, well, then you're not gonna be able to just, to do the audio if it's picking up attorney work product conversations between the counsel at the tables. I don't know what to, I mean, some adjustment's gonna need to be made. I doubt if they can hear it all the way over there, but what all's getting picked up?
Just when we were having a conversation.
The state,
I turned the audio off. I heard you. Whenever I hear a whistle.
well, I appreciate that, but I'd imagine it's gonna be pretty constant that they're gonna need to talk amongst themselves.
And it's happened multiple times in trial that people will text us, they can hear your conversations at the table. So this is a repeated issue that's been.
Okay, well, thank you for bringing it to my attention. Where's your feed, like your audio feed coming from? Where's it getting picked up from? Do you know where the mic is?
No, it's connected to the court system. So whatever feed you all give us.
All right, Ms. Persfield, can you get IT to get on that issue, please? She's watching on Zoom, I assume. Maybe I should text her too or email her too. Instant message her on my computer. Give me just a second.
I've never heard their conversations at that table unless they got the mic still on.
So you're attached to what, the Zoom?
Whatever feed the court gives.
I don't know what feed the court gets, but all right.
And plus, shit, we can tell by y'all body language, all that attitude y'all be having. Shit, don't nobody need to hear what y'all be saying. They ass be lying so damn bad. They'll have to pull the clips. Let me hear that shit. Because I've never heard a conversation at that table. Has anybody that normally watch this trial ever heard a state conversation? Right, that's the only time
All right, Ms. Persfield's reaching
I've
out.
heard when that mic don't be all the way off for sure. Just a minute ago, you could hear attorneys talking about statutes. I think they was talking loud though. They wasn't even trying to be discreet. I could be tripping though. I think they was just, I don't think they was trying to be discreet in that moment though. Yeah.
All right, do we want to turn to where we left off when we were last here, which was trying to sort out the nested hearsay in one of the wiretap conversations?
Your Honor?
Yes.
Before we turn the page, could I just get some clarity? Because I'm confused. The state, I believe, indicated that they thought the facts of the murder case involving Mr. Ryan were admissible in this trial, but the conviction wasn't. But then they started talking about limiting instructions. And I'm confused. Are they maintaining that the jury verdict from a separate jury is admissible against in this case? Or are they abandoning that and saying that they're going to get into the facts of this case?
We are saying, Your Honor, that the conviction itself is admissible and will be tendered, and that an instruction should be given that the certified that we intend to introduce, that conviction should be considered against Mr. Ryan only.
Oh my.
But the facts of the murder and what happened should be considered as evidence if they choose to, believe it, against anyone currently on trial.
All right, so it sounds like
Well-
you do intend to introduce a certified copy of the conviction,
Yes, Your
and that would be accompanied by a limiting instruction that is probably similar to the one I gave before, that that can only be considered against Mr. Ryan. Of course, he's charged with the Rico count, right?
He is.
Okay. And then they would present facts which they would hope to be able to establish not only that a murder occurred, but that the murder was part of the Rico conspiracy.
We would
And
introduce.
that would be admissible against everybody charged with the Rico count.
We would, right, much like some of the unresolved murders that are in the indictment. We would be introducing the evidence that Mr. Ryan and Mr. Blaylock did it, and what connection we believe it has to YSL, and what they did to promote YSL before, during, and or after. So that evidence we believe is admissible against, well, we know it's admissible against everybody on
Okay.
trial now.
All right, does that clarify?
Well, it clarified that we do not have an agreement, and I'm diametrically opposed to what the state is saying. Couple things. First of all, that verdict was not the verdict of the fact finders in this case, which
Sure.
we chose and are our jury, and that's Mr. Stillwell's jury.
All right.
Also, Your Honor, I'd like Your Honor to know that Mr. Ryan's case is currently on appeal. It's not a final judgment, it's on appeal.
All right.
And I guess I defer to Mr. Attorney Steele on this, because as I understood it, he was going through the law that would prevent them from presenting this as evidence. And it is evidence against us.
I'm sorry, when you say this, what do you mean?
The
Fact-
conviction.
Conviction?
I'm not worried about the facts. I understand the facts, but the conviction, and they want to use it as proof of an overt act, which as an
Only
element.
as to Mr. Ryan
Well,
is what they're saying.
well, no, they just said it against everyone as far as count one to Rico.
The facts that they're going to present, not the conviction.
Okay, well, I don't, as I understood the case law as Mr. Steele was reciting it, and maybe I'm wrong, but I thought we were at an understanding that they could, that's exactly what they could not do, is take a verdict from another jury and use it as substantive evidence against anyone in this case.
No, they can use it against, I think that they can use it against Mr. Ryan.
Well, they're using it against him for a RICO. This was not an admission by Mr. Ryan. This was not a plea of
No,
guilty.
he
This-
was found guilty. It's still a judgment of conviction.
Well, it's not a final
And-
judgment. It's on appeal.
Pendency of appeal doesn't matter in terms of admissibility. It's right there in the statute.
Okay, well, I understood the state said two different things, and so I was seeking clarity. I'm opposed to it. I'm stating my objection. I don't believe that if Mr. Ryan is charged with a RICO count along with my client, and they have the exact same element, and the jury's instructed that they need to find the commission of one of the overt acts, and they're told to consider the jury, the finding of a jury, a separate jury against Mr. Ryan. I don't know how they separate that. I don't know how a limiting instruction separates that and protects Mr. Stillwell's rights, and they wouldn't accept that same jury verdict against Mr. Stillwell and others for count one. I don't think a limiting instruction would be sufficient. I think they need to prove that case.
I think we have some case law that addresses that subject. I'd like to flesh it out, given Mr. Sharp's objection, but I'd preliminarily point the court to United States versus Palulo, Pelullo, 14 F third, 881 at 888. It's a Third Circuit 1994 case. And it specifically speaks to prior convictions being routinely admitted into evidence at subsequent Rico trials as an ordinary piece of evidence. A judgment is subject to evaluation by the
Slow down
fact-
a little bit.
Oh, I'm sorry.
A judgment what?
As a judgment, I'm sorry, as an ordinary piece of evidence, a judgment is subject to evaluation by the fact finder who can accept or reject such evidence as it deems appropriate. Also, United States versus Tocco, Tocco, 200 F third 401, in site 417 to 418. It's a Sixth Circuit 2000 case, finding the district court's admission of evidence of a co-defendant's prior conviction permissible to establish RICO predicate. Here it says because the evidence was not used as collateral estoppel, but again, these are cases that I would need to flesh out. These are just preliminary cases for the court's consideration, given the argument that I'm hearing Mr. Sharp make right now, that we
Okay.
would point to as a starting point.
All right. Well, we're gonna have to get that sorted out fairly quickly if we think that within the next 2 weeks, we're gonna get to this,
Yes, yes.
or so, 2 weeks or so. Okay. So, Mr. Shard, are you clear at least on what the state's position is?
Now,
Okay.
thank you.
All right, we ready to turn to that Garlington wiretap? Hmm? Oh, yeah, I'm not deciding that issue right now. We'll come back to that.
I don't feel like, dang, everything was quiet quick as hell. Y'all make sure y'all hit the like button, man. Y'all know I'm trying to get out my shadow ban. So y'all make sure y'all share the live, share. Run up the comments. Let YouTube know that y'all rocking out with Mickey Truth, man. We are watching YSL Rico trial live. They are doing some litigation. I'm gonna be honest, it has been an interesting morning. Normally I get kind of bored when they litigate, but I actually have been paying attention this morning. They have definitely kept me tuned in. So, and we've been tearing up the chat. So far so good. Like I said, if it does get dull, we'll switch gears. But so far, everybody is engaged. So we're gonna keep running it up and see what happens with this wiretap. Make sure you like, comment, share, subscribe. Tell a friend to pull up on your girl Mickey Truth. We is live with it.
Evidence before the Garlington wiretap evidence? Okay, then maybe we need to set aside the Garlington wiretap and deal with the evidence that's gonna come in against Ryan. Okay. We'll wait till he gets back, but just trying to figure out which thing to turn to next. Okay, that's fine. Let's take a quick break for anybody that needs to run to the restroom.
All right, so they're on their first break of the morning. And like I said, hey, it has been an interesting morning. Normally they breaks be about 10 minutes. I guess we'll be on break for 10 minutes. So what y'all thinking so far? I really, it's like, how can I work this? So like with the Ryan situation, right? It's like, just because he referenced YSL after this murder, they putting it on the case. It's crazy because even his father was like, he never known him to hang around per se YSL. Most of the witness said they don't know him as being part of YSL. They just like probably heard him through the neighborhood. I want to say, so the victim in the Ryan situation, good morning, Leah, was a teenager, and I believe Ryan was a teenager at the time too, if I'm not mistaken. I haven't really looked into that case, but I think possibly he was. But nevertheless, it is under appeal. And see, that's the whole like messed up part about the legal system, and why I tell y'all, in my opinion, it's definitely not about innocent or guilt, because you have a person who's convicted, obviously with some grounds that happened during the trial that made it possible to get an appeal. And now you can still use that conviction that's still up for question in the appellate court against me and others is wild to me. But welcome to the legal system. This trial has been stressful, confusing, cluttered, especially for YouTube. I don't know what to think anymore. Yeah. And imagine, listen, it's a lot of people on the jury that probably don't know what the hell going on. Little Rod was definitely a teenager. I thought so, I think he's only like 18, 19 now. I don't even think he's that old now. Yeah, he's a kid now, technically. Look it up. I had to think of his name. Oh yeah, he is the one when this happened. I forgot all about this last year. Hold on, let me pull it up for y'all. I don't know if y'all may remember this, but I forgot all about this. We'll watch it real quick.
Counsel, go ahead. Come and get him. Take children. He can stay over there. Yeah, he was getting out for what? Stay over there for him. Go ahead.
You smell like raw marijuana. When you walk back into the courtroom before, multiple people notice that you smell like raw marijuana. You're going to be strip searched. Do you have any on your person? You just want to go ahead and hand over right now? Yes, I can still smell it right here, right now. So that's fine. I understand that. I'm having a conversation with you before we go forward. So I need you to go ahead and take your clothes off, buddy.
I'm saying, well, I ain't almost right. Take your clothes off, buddy. What the hell y'all got?
Right. I'm just giving the instructions. I have right now.
I'll go ahead and take your shoes off.
Hold on.
You tried to give me my shirt, and you got your shirt today.
So you got a shirt today that smells like weed?
Yeah, I had to.
Go ahead and take the shirt off.
Yeah, but I have no idea. I was talking, Who told y'all to come?
Lieutenant Gibson
Lieutenant Gibson did.
No, hold on. They just went and talked to the judge.
She's on her way up here to talk. Gary Sources.
You can check it there.
You
got clothes on, so yeah. It's not hardcore. Yeah, no, I mean, it's, you can smell it.
You gotta get a shirt, bro. I don't know.
Thanks. Socks, please.
Will you squat down?
Give me a second.
I'm gonna take that over from. No, take everything off. I'm not, that's ragging, bro.
Right.
They about to show all that on this video. I ain't about, I don't know. Are they gonna show it or is it blurred out? Anybody that done watched this before? I don't want no smoke. Okay, so it seems like a lot of y'all have already watched this. Now he knew he was gonna have to squat and cough. Now he knew that shit. He knew that shit. So yeah. So if y'all remember that, this is the same person. I was trying to find out like what was his ground for appeal. That's what I was trying to get at. Get to that. No, they don't show it. Okay, so I'm gonna finish it out. I think it's only like a minute left.
Probable cause to do it right now. It still smells like raw marijuana in here. I understand what you're saying.
I don't got shit on me, bro.
I understand.
I just stripped, bro. I'm not a strip man, no, bro.
Ron, you have to take your clothes off. That's what a strip search is.
What you gonna take my clothes off?
I know you don't want to do this. I don't want to have to see you naked right now. Honestly, I don't. I don't get off on this. I don't feel good about this. But it's what has to happen because it smells like that.
What the fuck, bro? I don't got that on me, bro. I don't got that on me, bro. Take it off. Oh, bro. Ron, either take it off or we'll have to take it off of you. Oh, Ryan, get that wrong.
Just we'll get it over with, man. The quicker you do it, the quicker it'll be over with. I don't. Just please listen to me, man to man, right now. It's either I have to put you in handcuffs or take your underwear off you, which I don't want to do. I don't want to have to do that to another man. I'm trying to offer you to do this chance right now. I know you don't want to do that.
I need to talk to my lawyer or something.
You can in just a second.
I need to talk to my lawyer.
You can in just a second.
I'm getting script search for you to my weed, bro. Ain't nobody want to hear, bro. What the hell?
Don't. Stop.
Man,
Stop. Take it.
Man, bro, bro, come on, bro, I ain't getting that, bro.
No, take it.
Man, bro, I ain't getting that, bro. I ain't getting that.
Well, damn. That shit went off crazy as hell just now. All right, they didn't show. But ultimately, I was trying to find the the news article to find out. I heard that is painful as fuck though. That maneuver that they do, I heard that is painful. My daddy was telling me about that. I hear that's a painful maneuver to be in. All right, hold on, y'all. I'm trying to see what is all this popping up. All right. During recess in the trial, I knew all these shits was gonna continue to pop up. Says that a sizable amount of marijuana was discovered. Was discovered hidden on the person of YSL defendant Rodelius Ryan, who screams from a holding area touch off Amelie in court Wednesday. The sheriff says deputies had removed Ryan from court because they suspected Ryan had pot on him in court, and he screamed because he did not want to be searched. Young Thug was sitting at a table in the center. Hold on, I think I'm gonna play the video. In the center of the room as the drama unfolded. Everyone chill. Court officer said, clear the room. All right. I'm trying to see where they said they actually found it. Defendant is Christian Eppinger and Cordarius Dorsey then stood up and yelled for officers to let Ryan out of the holding cell. He didn't do anything wrong, one of them yelled. Eppinger's attorney, Eric Johnson, said Eppinger stood up because Ryan is his good friend and he was concerned for Ryan's safety. All of a sudden, they take Mr. Ryan, the young child. I mean, he's a kid. They take him to the back, and we can hear him screaming. And attorney for Dorsey told Wynn, we can hear him in the courtroom yelling for help, and we're all confused. The attorney told Wynn that right about that time, Ryan was escorted out. An officer who had earlier had an alleged altercation with Ryan was scheduled to take the stand. Is this a video? I think this is a video. Let's see. Y'all, we just buying time until their break is over. I didn't watch it.
Smelling marijuana.
All right, well, hold on, y'all, because if my audio is breaking up again and did this yesterday, let me check. Because I'm not playing nothing. We might have to cut the live short again today, but let me see. I'm gonna play this. I'm gonna grab my phone to see if it's on everybody or not. I'm still looking to see how much he had on him.
So they're getting ready to pull him out of the courtroom now. Now, mind you, body cameras, it starts to record and it picks up about 20 seconds prior to actually turning it on. So that's why it was a delay in the volume.
Counselors, go ahead. Yeah, he was getting out.
So they're escorting him back to the detention area. And you will hear the deputy explain to him what the situation is.
Multiple people in the seats on the ground marijuana. You're going to be straight searched. You have any other person, you just want to go ahead and hand over. I can still smell it right here, right now. That's fine. I understand that. I'm having a conversation with you before we go forward. You can go ahead and take your clothes off.
I said, well, I ain't almost
I'm not taking clothes off, buddy.
Right. I'm just giving you instructions.
I'm going to take your shoes off.
So you got a shirt today that's not like me?
Yeah, I had to.
Go ahead and take your shirt off.
Yeah, but I have no idea. I was told
I can tell you when he got some shoes. So those shoes don't belong to him.
Those ain't his shoes.
Okay.
Well,
All right, that's his dad that's talking right there. He's been on Infamous Sylvia channel before. So I skipped the parts that we had already watched already on the other video.
But now you see he has on a pair of boxers and then the polo underwear under the boxers.
I understand what you're saying. I understand. Ron, you have to take your clothes off. That's what it's
So what they're doing now is taking him to another cell to kind of get him further away from the courtroom. I mean, the courtroom. Yes, sir.
Stop. Oh, you want to do it here and just get it over with? I don't want to put you in handcuffs so we don't have to. Just get it over with. All right, stop. Ryan.
Now you see there's no swinging, no kicking.
Yeah, I've heard that shit is painful. My daddy said that shit is painful, and he looked little as hell. But yeah, I heard that shit is a painful maneuver for sure.
They're trying to take him down to the ground. 4 points of contact. One person is on the left arm, one person is on the right arm, and then you have a person at the leg, and another person at the other leg.
Slow down.
I know that's a random thing to think about in this moment, but yeah, it just, y'all know my attention goes to different places.
And you notice no one's knee is on him. He's turned to the side so he can breathe. Now he's grabbing the underwear so they won't be able to grab, take the underwear off of him.
He was screaming.
No one's on his arm.
All right, it looked like this video might show a little bit more than I need to show on YouTube. Oh, they be like, okay. So Lord, look, I don't want no smoke.
Just get it out.
Let's get it out. Goddamn. All right, I thought, okay, I wanted to see the other video. Yeah, y'all, I wasn't watching it around this time when all this was happening. I remember hearing about it, but I never actually watched it. Is this the video I wanted to see? Hey, listen. Some channels, if y'all have noticed with YouTube, they won't blur out shit, and they okay with it. But look, I'm not about to fuck up my monetization for none of y'all. I don't give a damn. So okay, so if I don't know if it's not blurred, I haven't watched this video before. I'm not taking no chances. Y'all don't donate enough to me for me to take chances like that on videos. Okay. So yeah, we just gonna, I think we got the, the umph of it, okay? Yeah, now he know they was gonna go up in that shit. Like I said, I've never done prison time. The closest thing was when I did DJJ time, juvenile time, and they gonna make you squat and cough. You know that shit. All right, let's watch this. I don't know if this is the same one, but let's see.
Here's what we know. Officials cleared the courtroom after commotion during the YSL trial. So this all happened with the rapper Young Thug sitting in the courtroom. So listen carefully to this audio so you can hear some type of screaming in the background. All right, so screaming, some sort of moaning. You see the activity here. You can hear the screams. About 90 seconds later, saw court officials restraining somebody, taking that person out. Seconds after that, they cleared the entire
Oh, that's the one that was sitting there acting like he was crazy. I remember him.
courtroom. So they're in recess right now. It's 5 o'clock. We have a Channel 2 Action News reporter and photographer at court right now. We're working to learn what even led up to the events you're seeing right here on your screen, and we'll bring it to you as soon as we get those updates.
Goddamn, his ass had no shut.
Ever wondered about this?
Damn, they ain't back yet. I could, man. We done definitely been watching videos and shit for over 10 minutes. But nevertheless, because we was talking about Mr. Ryan, I just had Googled him, and that was like the first thing that popped up. But yeah, he was definitely being extra as hell. Okay. Now I'm not saying that shit don't hurt, because my daddy done said that maneuver hurts for real, for real. But he was just being extra because he was screaming even when they wasn't touching him. And at that point, they see, my thing is, in that moment, especially when you're a prisoner, you already fucked. You know you fucked. Because you know no matter what you say, what you do, you're not going to get out of them checking you. That comes with it. You already know that you might well have just gave it up, take your charge. You're going to get the charge regardless. Take your charge and go sit back down. So yeah, he made it, rough on himself. He's a kid. He's been locked up since I want to say 2019, 2020, something like that. And he was only 19 last year. So his case is in appeal, and I think because he got a life sentence for that case. I don't even think you can do that. So I think he's gonna get less time as far as that. I don't think he's gonna end up stuck with that life sentence at all. No, it just what I'm saying, it just says sizable amount. And you know how the media and shit or the police can say sizable amount and it was only like a fucking eighth or some shit. So we don't even know. All right, we back at it. Not you coming over here asking what's up with Butter. Like, he always get caught with guns. Like, you got to check out my reaction to that. Like, we're not about to talk about him and his gun cases. There's really not much to say about it. He get caught with guns every 6 months.
Maybe we should turn to the evidence that's gonna come in on Mr. Ryan's on that. That'll happen before the wiretap evidence.
Yes, Ryan, I thought, are you talking about the email that Miss D. Williams sent?
I don't know. Did she send one recently?
I thought Ms. Abbasi and that was what we talked about a few moments ago. He said, the two of you need to get together by the end of next week to go through those items so that we wouldn't have to use the court's time to do that.
So I guess it was, yes, Mr. Williams' email from, well, it was a long time ago, about all of the exhibits.
Yes, Your Honor, and
okay,
I'll
so
get
y'all
with
will
Ms.
get
Abbasi
together on that.
Yes, to discuss a time.
Okay, and can you remind me, did the state decide that y'all can, I guess, concede that Mr. Ryan's statement to police is inadmissible, or no?
Yes, we can use that.
Yeah.
Okay, all right. I thought y'all had conceded that, but I hadn't written it down on this. So. Let me put that in the issues that have been dealt with folder.
The what?
One of the matters that were addressed in an email by Mr. Ryan's counsel was the Harold Bussey stabbing. I believe Mr. Abbasi or Mr. Williams moved in limine regarding excluding the evidence that Mr. Bussey was stabbed. Our argument about it being intrinsic, the court last said, or gave Ms. Abbasi an opportunity to give case law stating that things that were used after the fact, Ms. Abbasi can correct me where I'm wrong, but acts that occurred after indictment could not be presented. And I think in her brief, she indicated that, I don't want to speak for her, but I think she indicated that she found no case law in support of that position. So we're prepared to argue
Okay.
that. I'll let her speak.
Yeah, we submitted a brief and went through each of the possible admissible purposes. And as far as completing the story, something which happened after the indictment was following there. However, something which after indictment certainly could be part and parcel of something inextricably intertwined in the same facts and circumstances, but that's not this case. So the brief does put out in there that the intrinsic facts state is seeking to admit does not meet any of the criteria or exceptions, whatever you'd like to qualify it as, for those acts to be admitted. I don't know if the state is planning to respond. I did submit that several weeks ago.
Right, and I read it and I marked on it, and now all I need to do is find it. I need somebody to keep me organized. Does the state have a response?
We do, and
Did y'all file a response?
No, we made an argument that essentially is the same one we're going to make today, but based on what they've put forth, we'll respond specifically to the arguments that are asserted, put forth in Ms. Abbasi's brief. I think we presented case law, and I think that the court saw that case law. I won't speak for the court, but I believe the court saw and was satisfied that the case law does say the acts occurring after indictment are not precluded as evidence of the conspiracy.
Right, no, agreed, but it's two separate issues. I mean, if it's gonna be, they're not precluded just because they're post indictment, but if they're gonna be admitted as intrinsic evidence, then they have to fall within one of the things that makes them intrinsic evidence, that it's the same series of transactions, it's necessary to complete the story, or it's inextricably intertwined with the evidence about the charged offenses. So what are y'all contending that it is?
All of them. So in as much as the arguments that are put forth in Ms. Abbasi's brief seems to focus specifically on
You're quite right that I don't think there is a focus. I've never heard them state which theory they're proceeding under.
Right, yeah, you're saying it's not any of them.
Correct. I've never heard them state which of those three specific are.
So, Your Honor, I'll just tell Ms. Abbasi in the court right now. It is intrinsic to count one. Additionally, the conspiracy that it also is a part of is the YSL gang itself and the conspiracy that the gang itself makes up. I think we already presented some of the facts of the case to the court regarding the in concert action by five YSL members and two others of stabbing one person in defense of Mr. Ryan. And I know that the court has already read the indictment that describes, as the state alleges, the conspiracy itself being preserving, protecting, and enhancing the reputation
power, et cetera, of the enterprise through acts that include assault and threats of violence. And of course, I'm not reading the entire indictment, but in this particular case, it falls squarely under a number of actions that are intended to sort of circle the wagons around YSL members, show that they will stand up for each other and that they will commit violence on persons who they perceive as threats to members of YSL. Mr. Ryan, after he was indicted, there were several, at least one YSL member that we have listed as an overt act who makes assertions about Mr. Ryan and his murder charge and subsequent, I think, conviction. And there are people who perform acts during the course of his trial. At least one person that we believe were intended to intimidate a witness who was actually on the stand at the time. There are, by way of examples or analogies of other similar acts that are committed on behalf of YSL to show their solidarity. For instance, when Mr. Garlington is jumped, other members of YSL immediately jump in. We have evidence that when Mr. Copeland is jumped, at least one person in the courtroom now jumped, just jumped in just because. When it's one of them, they're going to come to their defense. The act itself was.
Hear all of this argument, it'd be great under 404B. I'm waiting to hear which of these three categories it falls into. We're talking about two different issues here. Which of the three, and then 404.
It is not 404B, it is intrinsic.
It could be both. I mean, I guess it would be intrinsic, but I mean, y'all haven't offered it as 404B, right? And you don't intend to, even if I rule against you on the intrinsic.
Well, if the court rules against this, it would be a different argument that we'd be prepared to make on a different day, because that's not something we were putting before the court
Okay.
today.
All right.
So the actions of Mr. Ryan and the other YSL members in concert in stabbing Mr. Bussey, when Ms. Abbasi asserts that they're not necessary to complete the story of the crime, this is our position, is that this conspiracy didn't stop at the jailhouse doors. It's ongoing. It's necessary that the jury sees that it is ongoing, to show to them the truth and the whole truth that we believe that our evidence reflects, to show them the extent to which YSL members go in order to preserve and protect not only their name, their own, but their reputation. Mr. Ryan, Mr. Blaylock, Mr. Eppinger, Mr. Myrick, and Mr. McMullen are seen in the photo that, I don't know that the court needs to see it, but if it does, we can present it on Zoom camera to show the concerted action on their part in stabbing Mr. Bussey. This particular screen grab of the video doesn't have 5 knives in the air like one of them does. This was just them all holding him down. And for the purposes of just this hearing right now, we'll just call it State's Exhibit 465, RR for rebellious Ryan.
All right.
Your Honor, I guess I'm kind of more confused now, because I think the state's purpose is they want to show that it's ongoing. So I don't know how they're using it to complete the story of the crime if their version is that it's not complete and it's ongoing. I don't see how those two square. It's not an element that the jury has to find
the gang is continuing. The only thing they need to prove is that by the date of indictment, this happened. It really doesn't matter as far as what the jury needs to know for the state to meet the required elements. Doesn't matter whether the gang is continuing.
All right, but the state can prove if it chooses
They sure can.
that it's an ongoing conspiracy.
Sure, but that doesn't make it necessary to complete the crime.
Well, necessary to complete the story of the crime, and I guess the story of the crime is
Ongoing and continuous conspiracy that is YSL, its enterprise, and the members committing these particular acts and crimes for the purposes listed in the indictment under the definition of the conspiracy itself. And this act is not something that is obviously relevant to the issue of whether or not the defendants are or are not guilty of count one in terms of what we're alleging that they conspired to do. It certainly would be an overact under the definition of overact of count one. So it would go to prove count one as to each of the defendants. It's therefore relevant, highly relevant as to that particular issue. It's presumptively, of course, the court is the gatekeeper, but under 402, because of its relevance, it's presumptively admissible. Under 403, Your Honor, there's nothing about it that is so substantially more prejudicial than probative, given its highly probative nature. Do we have the Zoom up here? Can we put it up and put it on the Zoom? Considering it's coming just, we're not in yet.
all right. Ms. Abbasi, can you remind me, and I don't know which one of y'all cited Murphy. Was that you, Ms. Abbasi? The part about integral and natural part of the witness's accounts of the circumstances surrounding the offenses, which factor did that go to?
I specifically did not cite that case. I did discuss whether it would be integral, natural part of what happened. I didn't cite him.
Okay, well, maybe it was just one I.
I did want to touch on one thing the state said, because I think we're getting into dangerous territory. The state said that this act in and of itself could constitute an overact to support the verdict. Well, now we're talking about trying to prove the charges against the defendant based on something not in the indictment.
Well, and you know, that's an issue that I've got written down here as something that y'all owe me law on, whether an overt act not listed could be the sole basis for a conviction.
Right, we do, and I think at some point.
Still waiting on that law.
No, we actually, I think at some point, and I might be wrong about this, but a contrary position was presented, and whatever case was cited, did not support that position. And we have affirmative case law that we present in the form of a brief to the court.
All right, will you go ahead and get that filed can you get it filed? When can you get it filed? By Monday? By Friday? All right, by Monday.
Your Honor, I can get to the part kind of the contrary case law, but in the appellate, I know it sounds doesn't sound to square up, but it leads to an inconsistent verdict that perhaps some of the jurors found the defendants guilty based on the acts which were in indictment, and perhaps some of them found the defendants guilty on acts which were not.
I mean, it's gonna be real fun when we get to the verdict form. I think that we're gonna have to get really specific about what they're finding, because I don't think it can be that 6 found one and 3 found another and 2 found a third.
I think that this precise situation came up in Cotman, and I could be very, very wrong. I read it, I glanced over it briefly, but I think that the court found that given that the court instructed the jurors that their verdict had to be unanimous, that it did not present a reversible issue. The defense argued, or the appellants had argued, that there was no way to tell whether or not they all agreed on the same overt act. But in giving the court the brief that we intend to present, I think we can address that as well. I think that that part is easily
All right, so
addressed.
that'll be two different issues. There's, can an overt act that's not listed in the indictment be the basis, the sole basis to support the conviction?
Mhm.
But then there's also, does the jury need to find unanimously this overt act, specific overt acts? Do they need to delineate which overt acts they are unanimously finding exist to each defendant?
Right, and I think that as it relates to our previous discussion that the court said we would address a little bit later, you know, whether we number them or whatever,
Mhm.
I just off the top of my head, I think that them listing an act that they found unanimously had been committed
Mhm.
as to the defendants, I think would suffice.
Okay, well, if we all agree on that, then we don't need a brief on that.
Okay. So, I'm sorry, Mr. Boston.
Hmm?
I don't know if we made it to the 403 part on this.
No, we hadn't. We sort of got sidetracked, but.
Make sure I'm not.
All
All
right.
right, so we all agree that the jury is going to need to delineate. We unanimously find this overt act exists as to each defendant, right? I mean, we're going to break each defendant's counts out separately, and
I think that
I agree, but think that.
will, and to make certain that we present clearly to the juror, to the court, we
Uh-huh.
do believe, yes, that the jurors have to make a unanimous decision as to each defendant and as to their overt acts, but as to whether the overt act it finds as to one unanimously has to, you know, deal with the others.
I know, I mean, it can be wholly entirely separate as to each defendant. It needs to be a separate determination as to each defendant.
Yeah.
But for each individual defendant, does the state agree that the jury has to unanimously find two overt acts, one of which needs to, or happen within the statute of limitations?
We agree they have to at least find one
Okay.
that happened within the statute of
And
limitations.
it needs to be unanimous that, let's say they all find overt act 66, whatever
believe-
that is.
I believe it's safest that they find
Okay.
Unanimously.
Okay. All right,
And
then I don't
we-
need law on that because we'll just do that the safe way, whether it needs to happen that way or not. Okay, so back to, so I still will need by Monday whether an overt act not listed can be the sole basis for the conviction. And now we will go back to to what we were talking about, which is this
the intrinsic
allegedly intrinsic act.
So Mr. Ryan, given Mr. Blaylock is not here, but I will, since they were the two that were charged with the murder in one of the overt acts listed on the indictment, Your Honor, Mr. Ryan and Mr. Blaylock have entered a plea of not guilty to count one.
Mhm.
And they are obviously charged with committing an act of violence against a person as alleged in the indictment in a manner that furthered the interests of the enterprise in the conspiracy. The three, I guess, points that Ms. Abbasi referenced in her brief were that the intrinsic or the act needed to arise out of the same transaction or series of transactions as the charged offenses necessary to complete the story of the crime, or is inextricably intertwined with the evidence regarding the uncharged offenses. And there is an or, so it does not have to be all three. So given that the jury will hear evidence of Mr. Ryan's and Mr. Blaylock's concerted efforts as they related to Mr. Holmes. They will hear evidence of Mr. Ryan's actions after the murder of Mr. Holmes. They'll hear evidence about their connections to YSL, but the fact that you have other members of YSL acting on behalf of Mr. Ryan to support him in a violent way against another person whom they allege only messed with Mr. Ryan's commissary, stabbing him just because he messed with Mr. Ryan's commissary.
What's up, FDB?
Show
Appreciate the super
the
chat.
extent to which members of YSL go to assert their dominance, even in a situation like the Rice Street jail. And to protect one another, to show that you don't mess with one of our own. The argument obviously can be made by anyone. Yeah, this is not really what it's all about. But in terms of what the state is required to prove beyond a reasonable doubt to the jury, we alone bear that burden, given that it's evidence that there is violence committed on behalf of a member of YSL by members of YSL. We believe that it shows that.
Hold on, I got to pause this real quick. Yo, shout out to FDB on the 20th super on the live stream. I appreciate it. He always come through and show love to the channel. I really, really appreciate it. And I just want to make sure I say that. Okay. Appreciate you very much.
The gang itself conducts itself in a particular way. And that the.
Okay, let's stop interrupting though. I mean, I assume she'll get to it at some point.
That the gang itself conducts itself in a particular way. And in Johnson versus State, a Supreme Court of Georgia case, whose site is 312 Georgia 481, decided September 21st, 2021. At Penn site 491, the court said that, of course, evidence is admissible as intrinsic when those three elements that we just mentioned exist. And they went on to expound and say, in applying this test, we have explained the evidence pertaining to the chain of events, explaining the context, motive, and setup of the crime is properly admitted. If it is linked in time and circumstances with the charged crime, the defendants, the YSL members, are all together. They are the ones that are included in or that participated in the stabbing of Mr. Bussey, are all housed together at the Rice Street jail. The time frame is shortly after they're put together in that situation, all together in the Rice Street jail. In this particular case, in Johnson, it has a set of circumstances that are not exactly the same as this, but we believe are analogous in many ways. In Johnson, of course, the appellant was charged with participating in criminal street gang activity, and the state's theory was that he was involved in the gambling house shootings with Blood Gang affiliate Porter and several unidentified assailants in another restaurant shooting. The evidence related, as the court found, to the Boulevard Place shootings added significant weight to that theory because the evidence was linked in time and circumstances with the charged crimes, and one victim was a member of a violent gang. We are not alleging that it is on all fours with our particular case, but to the extent that the Johnson court found it pertinent to say that the intrinsic act, or the act that the state alleged was intrinsic, added significant weight to the state's theory. For these reasons, we believe that that is analogous to our case as well, with 5 people, 7 total, acting in the same, overacting with an extreme amount of violence on behalf of one person, whose connection, we believe, with the 5 YSL members is just they are all YSL members and they are acting protectively towards him. We have, we believe that that incident adds significant weight to our theory of the willingness of YSL members to participate in that enterprise in a manner involving violence to protect the dominance and the members of the enterprise and the gang itself. So the court found that even though the state didn't charge appellant in connecting, evidence of the incident was relevant to disputed issues in this case. So as Mr. Ryan has entered a plea of not guilty to count 1, conspiring to violate the Racketeer Influenced and Corrupt Organizations Act, by participating in YSL through these acts or conspiring to participate in them, then evidence of the involvement of Mr. Blaylock, Mr. Ryan, Mr. Eppinger, Mr. McMullen, and Mr. Myrick, all of whom are also charged in this indictment with the conspiracy. Evidence of Eppinger being charged with the shooting of an officer, evidence that Ryan, who was promoting YSL while in prison when Eppinger got a bond for shooting at the police, that Blaylock is a co-defendant on the murder of Mr. Holmes, which is an overt act here, and that Demise McMullen is a named co-defendant on the 2015 murder in the same indictment, shows how intertwined these people, this type of action, and this gang itself is with one another. They're all inextricably intertwined with the evidence regarding the uncharged offense, which is the stabbing of Mr. Bussey. So we believe that it satisfies the requirement of the requirements of being an intrinsic act.
Okay, which of the 3?
The third one, we believe is the strongest in that it's inextricably intertwined with the evidence regarding the uncharged offense.
No, it's the charge. It should read the charged offense, right? I mean, it needs to be inextricable, right?
Yes, that the case is citing it wrong. Yes, thank you. And that being count 1, the conspiracy.
So how is it, and you think it's also necessary to complete the story of the crime, right? You're not asserting that's the same series of transactions as the charged offense, are you?
When the court says the same series of transactions, we believe that it's an overt act, in as much as it could be considered an overt act to promote, to support the gang. So in as much as it is or can be considered an overt act for count 1, and that it is gang activity, which it is.
All right,
And
I'm not quite sure where I got this language, but I jotted down And I think this is kind of the definition of inextricably, or an explanation of inextricably intertwined with the evidence regarding the charged offense, is that it is an integral and natural part of a witness's accounts of the circumstances surrounding the offenses in the indictment. Anybody know if that's as to, that's the explanation for what it means to be inextricably intertwined?
I think that came from Murphy.
Williams versus State, 302 Florida 474. Cited in the brief.
What year it was, Williams?
2017, it's cited to 11th Circuit.
Okay, and I think that language is also in a Court of Appeals case in 2020.
Okay, so, but I mean, if that's what it means for it to be inextricably intertwined with the evidence regarding the charged offense, how is that an integral and natural part of a witness's accounts of the circumstances surrounding the indicted offense?
So if the indicted offense is the conspiracy itself, and our witnesses talk about what they've observed, and we have evidence of what has occurred to further that conspiracy.
So would this be a witness who's being presented regardless, or is this a witness as to, I mean, obviously, if they're just coming in to testify about what happened in the jail, that wouldn't be the same thing, because I would have already made the determination, oh yeah, you can talk about this. Is there going to be any witness who there's no way they can give their account of how it is that any of these defendants is guilty of Rico without telling the jury about the stabbing?
No, we're not saying that. We're not saying that at all.
So then
No.
it's not inextricably intertwined.
But it does, it's an uncharged offense. That arises out of the same transaction or series of transactions as the charged offense of count 1. And the series of transactions is the acts of violence that have been described. One of the overt acts, as I said, is the murder of Mr. Holmes by Mr. Blaylock and Mr. Ryan, as we've alleged in the indictment.
And then how does this arise out of that transaction?
The series of transactions, one of them is that the series of transactions is the set of actions that occur after, before, during, and after that murder itself. The series of transactions are the overt acts that help promote the purposes of the conspiracy. You have Woody Lee posting, I'm sorry, we made you a thug, so early little thug. You have people who are acting within YSL in support of Mr. Ryan. Mr. Ryan essentially talking about staying true to YSL regardless of his circumstances after the murder.
All right, and are all of those overt acts?
Yes, those that I just named are, yes, alleged overt acts. So the series of transactions, we would argue, is not a simple matter as on Monday, July 3rd, he got up, went to the store, bought a gun, did that. It's
all right, remind me when the jail stabbing occurred.
It was February the 1st. January the 1st of 31st of 2023.
January 31st, 2023.
Yes.
And he'd been in prison, I guess, since 2019. When did they all get moved to the jail?
Mr. Ryan, I think, and Mr. Blaylock, those 5 co-defendants were, I'd have to look and see in Odyssey when they were transported, put together in.
Roughly.
Thank
Okay,
you.
Approximately.
okay, that's, I mean, approximate is fine.
And also, Your Honor, under 104, and I get that we are still hashing out whether or not it's intrinsic. Once the court makes that determination, and we believe that it's clearly intrinsic regarding the conspiracy and the gang itself, there's another argument in support of its admission and use at trial that we make under one of the other rules of evidence, but not until we finish this part.
Well, I'm curious now as to what that would be.
Just that under rule. And I'm also curious about how the court will see or not see this position that I'm offering. But under 24-104, which specifically deals with the court handling the admissibility of evidence and the court's determination of it. 24-104E expressly says that this code section shall not limit the right of a party to introduce before the jury evidence relevant to weight or credibility. And so to the extent that part of our evidence, and it doesn't, speak to the weight of the evidence of the murder, but we believe that it substantiates and it corroborates our assertion via the overt acts that we have listed, that there is this conspiracy and that there are efforts that are continually made by members of YSL to support and protect one another and to advance the dominance and notoriety of the gang through acts of violence and assault.
All right, well, I do not think 104 has any bearing whatsoever on whether y'all can admit it before the jury.
Okay, see, I know.
Okay, so that takes care of that one. All right, do you have any, can you look, if you haven't yet, for any case law that deals with kind of a similar set of facts? Mr. Atkins is shaking his head, yes.
Since
he
is.
can look for that.
Oh, that is, we definitely can. I was just trying to make sure that I fully got what the court was saying. So in saying the same set of facts, is the court speaking that specific as to, somebody jumping somebody?
Well, I mean, yeah, ideally, if you could get that, that would be great. But no, it doesn't have to be that specific, but something that deals with gangs and or Rico, because what I hear you saying, or what I think I understand you to be saying, is that part of why this is intrinsic is because it's necessary to give a full story of how YSL is this ongoing criminal enterprise that uses violence to protect their members.
Right.
Am I understanding you correctly?
You are, and to assert its dominance. And in support of that, I also say that each of the members of YSL, Blaylock, Eppinger, McMullen, Ryan, and Fleetwood, had all, I believe all of them have been brought in from prison for YSL related offenses that they had been convicted of. Eppinger had been sentenced to prison off of a probation revocation for an armed robbery after he shot Officer Rogers. That was a YSL related incident. Mr. Fleetwood had been brought in from prison after shooting at Milton Howard, who at the time was driving wife and Lucci's vehicle with tinted windows. So the argument obviously could be made. He didn't know it was Mr. Howard. He knew it was an ops car. So all these people are all incarcerated because of YSL related offenses. And then you put them all in the same little area, and they are once more acting as one single bullet against somebody they believe is a threat. But I can and we will look for a case on all fours with this particular set of circumstances.
Okay. I mean, I honestly think the 403 argument is easier than whether this is intrinsic, but yeah, I'll go ahead and hear that because maybe that'll be dispositive of this issue.
So would Ms. Abbasi, should I let her go first, sit down and see the floor? Does the court want to hear from the state?
It's in the brief, so I'll let you begin.
Well, I mean,
they have the burden. I'll give you the.
All you really say in the brief is it doesn't meet 403. You don't really say why.
Well, it's that it has to survive the balancing.
Okay, well, that's pretty clear.
To exclude what is a scan or cumulative over court, I think everything in here we're dealing with is scant and cumulative. There are, I don't want to get wrong, how many other acts in here the state can prove. These are not necessary. I'm sorry. But that in the 403 analysis, the court should determine the prosecutorial need, degree of similarity, and temporal remoteness. There are 191 overt acts. I think by the time the jury has heard all of those, they will have heard quite a bit of evidence regarding how gangs operate, examples of criminal street gang activity already. Quite a bit. I'm sure by November there will be more. Don't think there's any prosecutorial need to be coming up with these things additionally. There is plenty. Your Honor is able to exclude evidence which is cumulative, which is of course prejudicial, and a waste of time. I think that's where we're getting to in this circumstance. Clearly, there was enough evidence for the grand jury to return an indictment.
Well,
they heard this.
that's a lot lower standard.
It is, but if even that lower standard, it was met there, then I don't see how it suddenly become necessary here.
Okay. Go ahead.
Judge, I've heard, and everyone I believe has heard a lot about the notion of the evidence being cumulative, as if there is a certain amount of evidence, the state who bears this very high burden, I'm sure we'll hear told over and over again in closing arguments, that the state should be allowed to present to meet that very high burden. And I don't believe that cumulative evidence means proof of a different kind to show or to prove the same act. Just because the state has 150 ways to prove that the defendants conspired to violate the Georgia Rico statute, and the state, in an effort to ensure that each of its victims are adequately represented and that the jury hears sufficient evidence to allow it to convict each of the defendants, doesn't mean that the state should be constrained to putting up one piece of evidence, one picture showing somebody throwing up a gang sign.
Can I ask you a question? How many of your overt acts, if any, are assaults or aggravated assaults that are designed to either protect alleged members of YSL or promote or continue the, I can't remember the word you said, but the dominance, assert the dominance of YSL?
As it relates to Mr. Ryan, or just in general?
In general, since the argument is this is done to protect members of YSL and
to assert their dominance.
Assert the dominance of YSL.
Okay. since an overact does not have to be a crime, I'll just name them, of course. So number 9, where Defendant Williams asserts in one of his songs, YSL.
No, that is not what I mean. I don't mean saying you're gonna do something. I mean actual assaults on people.
We have Mr. Holmes's death is alleged by the state to have been a murder of someone that they believe to have been a member of a rival gang.
All right, so
Mr.
I'm sorry. I mean, I guess maybe, so because it's a rival gang, that would be dominance.
Yes.
And
it's-
that's overt act, what, 79 or 69?
And I can also even be more precise there as I look for that number 79 or 69. Mr. Drinks's murder is alleged to have been a direct retaliation for the death of 2 people who were
Okay.
associates.
Your Honor,
Mhm.
I'm sorry, I'm just trying to
69.
I'm trying
determine
to
what you're
figure-
asking. Are you asking what the indictment alleges?
What,
Is,
yeah, overt acts.
well, the
alleged
indictment,
in the
as I
indictment.
understand it, just broadly alleges that the overt acts are done to that, for those purposes. The indictment broadly alleges several purposes and doesn't delineate which overt acts are designed to do what. So the answer, as far as I understand your question, would be all of them. They've
All right,
alleged
well,
all of them.
But
I mean, I'm asking the state sort of what, I appreciate that position, but I think I mean it a little bit differently than that. And yeah, sure, they could end up saying every one of these does all of these things, but I'm kind of asking them to be focused on aggravated assaults, obviously, or worse, murder, that are for these very specific purposes.
So to answer your question about the number for that murder, it was overt act number 79.
All right.
Also, the act on 4/28 by Mr. McMullen.
Overt act number
April
28?
April
Oh,
28th.
Okay, yeah.
I'm looking at them in chronological order.
All right, that's fine.
The act by Mr. Garlington, Mr. Sledge, that act of shooting Miss.
Are we talking about things like rival gang type incidents?
My understanding of what the court said
I
is
just
what
want to know what
acts
the state's position is.
that were done to acts of violence done to promote either the notoriety or to protect
the members of YSL or to promote the dominance of YSL.
So the shooting, we believe, by Mr. Winfrey of Lil Wayne's tour bus, which would have been a different one. It's encapsulated in 39 and 40. The shooting of by Mr. Murphy.
I think the judge got a point of asking the state these questions. The defense just need to sit back and let it play out for right now.
Do you have any other overt acts where members or alleged members of YSL are basically doing a beat down of anybody because somebody from YSL got threatened or attacked?
We have other ones where they're shooting at other members, and we have where they, for instance, Mr. Kendrick and Mr. Arnold go out and plan to shoot somebody because someone jumped on Mr. Arnold in a club.
And that's an overt act?
It is. It is. Where also I think we have. Yeah. And they are, I think, Acts 41 through 45 is the
Okay.
This is the murder
All right.
on the 28th that or the aggravated assault that I talked about.
Okay. All right, well, y'all see if you can find me some more on point factually case law, please.
Okay.
And
Is the
I know
court,
y'all want a decision, but
that's so,
we're gonna come back to it yet again.
And Your Honor, in terms of the number of acts that we've enumerated in here, does the court want specifics or just the number?
Yeah, that's right. I mean, you've told me enough. That's fine.
Okay.
I mean, it's not like that's critical to my determination.
Okay.
I just was wondering if there were so many that this was something that would really be cumulative, but it doesn't sound like you really have anything that similar to this.
And as well, Judge, in terms of judging whether or not something is substantially more prejudicial than probative, it would have to, I think I've said it before, it would need to tend to sway the jury to convict the defendants on a ground different than something that has been alleged in the indictment. And given the allegations that we've made, we don't believe that this comes near that category of cases or circumstances. As well, Judge, I know the court is aware, but just to put it out there, 403 is, all of these rules of evidence are rules that favor admission. And so 403 is not to be used as been alleged to limit the state's ability to present evidence so much as it is a permissive statute that under very rare circumstances should be used to exclude relevant evidence. And the mere fact that a defendant may feel that, oh, the state has too much evidence against me, is not one of those circumstances that the courts have recognized.
So actually do speak about prosecutorial need.
She done put her foot in her mouth. And she knows she ain't ready for that.
That the argument throughout is that YSL is a gang, that everything that has been, that YSL is a music label, that everything anybody does is just their own independent act that has nothing to do with YSL from day one, from openings throughout up to even now. The assertion by every defendant is, and even the witnesses, I did it for myself, by myself. Every step of the way, the state is having to rebut that assertion that this is just me. I'm a criminal, but they aren't.
Okay.
So to the extent that there's no one here willing to stipulate that crimes are being committed by them and others with whom they've conspired to promote or on behalf of YSL, the state has a very strong need to present evidence of one, concerted efforts to commit the acts that we've alleged, to show the conspiracy between the defendants, and to show the purpose behind their concerted efforts.
All right, thank you.
Your Honor, I'm
Yes,
just looking
ma'am.
here at some case law on prosecutorial need to see what I have to answer Your Honor's question in that respect. It's in 403 itself, in case law, kind of more specific. going to keep looking, I'm looking as I am speaking here. As far as the prosecutorial need, I'm looking at cases where the need is there's no other source for that information, or at least limited sources of that information. I'm not sure how many hours of gang expert testimony the jury has already heard from about how a crime can further a gang or be part of a gang. I think the need to that point on this principle, that there is no need. They've heard about it in depth. They will continue to hear about it. And as I said, I'm trying to look and see if I can get any more case laws specify if we have a level or a test for what need is.
All right. Thank you. Well, if you find something else, feel free to just, shoot it over in an email that you share with everybody. That'll be fine. It doesn't need to, I mean, if you want to file it as a brief, that's also fine, but.
What I've got, just looking at some case notes here. Prosecutorial need to induce a prior rape-related incident to show. Yes, I'm sorry. Explaining that the prosecutorial need to introduce a prior rape-related incident to show the defendant's intent was high because there was little other evidence supporting the charge of aggravated assault with intent to rape. That is a case, Kirby versus State, 304 Georgia at 483. And I haven't read that case. I'm looking at it. It is cited within Jackson versus State, 306 Georgia, 69 from 2019.
All right.
And Your Honor, if we get clarification, is that a 404B case or a 414 case or 413 case, Kirby?
This is addressing a 403 issue.
Is it in the context of a 404B?
I don't know, but it's not a different analysis under 403.
As I said, I've not read the full case. It is
Yeah,
just
I mean, it's
stated.
fine. I understand the concept. Okay, let's set that aside and move on to something else. So there was I've got some notes of things we were going to circle back to. And one of them was a video of somebody smoking pot wearing a chain and it saying some things. BB maybe and Eppinger, some about robbing Smith. What was that about?
Yes, I believe that Mr. Shard, we were supposed to narrow
It
down
was-
what video
yeah.
the state we were going
Okay.
to admit. I sent that over a few weeks ago, which ones we intended to use. I'm not sure we've been able just to talk about it in light of the last couple of weeks.
Okay, well, these are notes from back when we had that non-jury week, which I feel like has been a while ago now.
Yes, it was the week of August 19th, Your Honor.
Yeah, that's what I thought. So and that, I guess that was with regard to counts 27 through 29, maybe, is I think what I wrote down.
Yes, Your Honor.
So is that a video y'all intend to utilize?
We sent over, there are portions of that video we intended to utilize. I believe that the portion that was at issue is not a portion that we need to publish to the jury, Your Honor.
You're not going to show the jury?
Portions of the video. So the video is maybe approximately 5 to 7 minutes, and there's a portion, and I want to pull up my notes to see what I actually sent over to defense counsel as to what timestamps we intend to use, but a portion of it is relevant because it shows Mr. Eppinger and Mr. BB, the two
Mhm.
people alleged to have committed this armed robbery,
Right.
on the phone. And a portion of that video, Mr. Eppinger appears in I think it's like a Instagram picture, an Instagram video and BB shows him the chain, but there's another portion of the video in which Mr. BB is pointing a weapon at the camera. So there's just relevant portions, and we just haven't had the opportunity to discuss it, Your Honor. And I can let defense counsel know what date I sent over what the state intends to show.
All right. Does defense counsel still object to whatever portions those were?
Yes, I'll re-forward the email. August 23rd at about 1:55 p.m. God bless you.
Bless you.
Sent are approximately 5 clips that probably total together about 6 minutes of actual viewing. Is that about right, Ms. Hill?
Yes, sir.
Okay, so in all honesty, we haven't had a group this is all acts involving someone that's not sitting here. And if we could have a couple minutes
Okay.
just to talk as a group to figure out
You may.
what our stance is. on
All right,
this.
and you know what? I may have y'all do that over the lunch hour. So the next thing I had us circling back on was, and I guess maybe these were from I don't know, we were going through maybe one of the sets of statements, because I've got like page 2, 523, 513. Oh, these were the wiretaps, maybe. Big Nick.
Yeah.
Waters Road. And then, oh, the comment about, yeah, this was the wiretap stuff, the flipping the car and laughing about that. And the state had said y'all were gonna narrow what you wanted to use from that and let us know. Do you recall that?
Just trying to remember flipping the car portion.
I don't know. It was there were two reference numbers. One of them was 513, one of them was 523. It was on that chart that you gave us, I think. On the second page of it, Garlington talking about how they came through and thought they were going to come back and they were going to get ready to light them up, laughing about Shamel Drink's murder and the need to re-up on drugs to sell. And I had determined that the drug part was in, but y'all were gonna look again at that other part. You said there was a non-hearsay purpose for it. Did did y'all ever go back and do that?
By lunch, we can.
Okay.
We'll be able to have an answer by lunchtime.
Yes.
Would you kindly just repeat the two reference numbers?
Yes, 513 or 523. On the chart, it's 513.
Thank you.
And then when we got to 1109 or 1124, there was an argument that that shouldn't come in against Nichols or Stillwell because they had already been arrested at the time and somebody was going to provide law on that.
Did that fall under the broader proposition that the court sort of touched on earlier regarding whether or not overacts occurring after arrest could be used to prove the conspiracy itself, which would include people who have been arrested prior to the act being committed? If it did, we'd like to sort of address it.
I mean, I think y'all would need to establish that they're still a part of the ongoing conspiracy.
Make sure you like, comment, share, subscribe. Tell a friend to pull up on your girl, Mickey Truth. We is live with it.
Listened to and did re-listen to the part that on the chart is 1974, and I think the other reference was 1999. And this was I don't know if the argument was 403 there. Confusion, I think, was the argument. And upon re-listening, I don't find that to be a 403 issue. So that is admissible. That was about as far as we had gotten. And then, of course, we still need to circle back on the that one that we got bogged down with the nested hearsay with Garlington talking to Funk, who talked to Quay, who talked to Rel. So why don't we break for lunch? Y'all got some tasks to do over the lunch break. Do you have the material for me to look at? Yeah, it's not noon yet. It's about 1/4 till noon, but. Okay. All right. Will you just, are you gonna email it or bring it as a hard copy or what's? Okay. All right. Please do that over the lunch break. Let's reconvene at 1:15.
Yes, Your Honor, and I also put 460 on top of
My copy of 460. We never did find.
I found our copy.
Okay, great. Thank you. Thanks.
All right, y'all. So they on lunch break. Hold on, give me a second. Y'all was going something. They just be picking random times on the lunch. I'm trying to say, do I want to wait for it to come back? Because I really got some things I need to do. All right, y'all. This is what we're gonna do. I'm gonna go ahead and end for today. Because I got some things I need to do. So I really don't have a filler for the lunch break. That page on the hard copy. So I appreciate y'all for pulling up. Y'all already know I'll be back at it tomorrow, 8:45 a.m. Eastern time, for the continuance of YSL Rico trial. The jury will be back in tomorrow. I'll have some videos dropping between now and then because I got some reactions to do. But yeah, I'm gonna go ahead and get up out here so I can handle what I got to handle instead of having y'all sitting in silence for the next hour. Okay. Y'all enjoy the rest of y'all day. I appreciate y'all pulling up. And as always, y'all know everything I say is my opinion, and y'all know how I feel about my opinion. And like I said throughout the video, that's my opinion. And if you don't like it, guess what? I'm like, fuck yeah. Hold on, wait, before I go, y'all make sure y'all tap in with me to book your slot. A lot of y'all be hitting me up on Instagram and the email wanting to just talk about content, whether you're an up-and-coming content creator or somebody just got questions about cases or whatever. Book your consultation with me now. The information is on the screen. Hey, make sure you get your slot, because my slots be filling up fast. Mickey talks the truth. Okay. I got truth on my mind. I got truth on my mind. I got truth on my mind. Truth on my mind.
Hey, listen, you are now rocking with Mickey Truth. She live up to her name, not the fame. So make sure y'all subscribe to her channel and stay updated on what's real. Bye.
Good reporting ass Mickey.
We love you, Mickey.
Mickey talks the truth.